David, what's up?
Not much. How are you?
I'm doing well. Good to see you today.
Likewise. Brandon, I think that it's funny that you and I may be the only guys out there who view a casual conversation as involving suits and ties.
I'm not wearing a suit, just a tie.
Oh, there I go, clipping out again. Brandon, I'm gonna turn off my video for just a half second. I'll clip it back on. Go ahead and get going.
Sure,
Let's get going.
No problem. Well, hi everybody. Thanks for joining us today. See lots of familiar names out there for us. So hi everybody. Appreciate you guys, and hopefully our time together this afternoon can be one that is useful and helpful as we think about all the various issues that are going on for our school districts as we get ready to start the 2021-2022 school year. So please, as we go through things today, use the Q&A feature to ask us questions. We've already got a couple great ones.
Yes.
On a variety of topics to think about. So as we walk through our time together today, we really want to spend it, as we said, more informally answering your questions. We know that some of our, back to school plans are certainly a hot topic for us. There's a ton of legislation out there, some of which the governor's already signed, others that we anticipate will be signed here in the coming weeks for us, as well as other school law issues hanging out there for us to be thinking about. So, David, any initial thoughts before we start jumping in with some of our questions?
No, I think it would be fair at this point to say that this year feels an awful lot like last year, maybe more so than any of us had hoped. I would say the only difference from last year is that last year, the only thing you had to contend with was COVID. Nothing else really mattered at that point. This year, as we sort of are in this delicate dance of sort of returning to normal, but also kind of not returning to normal, we also have all the other myriad things that we've got to deal with. As I see some of the questions coming in with some of the new laws, and also a lot of the political things that have come up over the year, I think this is going to prove to be a much tougher year for administrators than last year was. The good news, though, is after last year, I couldn't be any more convinced that we have the tools to do what we need to do, and I think that last year prepared us well for what we've got coming this year.
Yeah, absolutely. Well, let's jump right in. I think that we need to start realistically with some of these issues with back to school plans. I think that makes sense as a place to start based on the questions that are coming in, some of the questions that we got ahead of time. And I think here's kind of the big picture question that's out there. And I think this is a question I've heard many times over the last week or so as things keep changing, right? I mean, David, just within the last couple hours, we've got updated guidance again from ISB. So you'll have into your inbox that you see that things are slightly altered from where they were when we all arrived at our desks this morning. But I think the issue here is, of course, that recommended versus required, right? Masks are the big question, and because as we sit here right now, things could change, that we don't have the same type of mandate or enforcement that we had last year as related to masks, via either executive order or emergency regulations or ISB's more firm stance. Is there risk in having a mask optional policy?
Yes, enormous.
Yes, plainly it is. I think that, I'll jump in on this, David, and then you can, share your thoughts. I think that we recognize that the decision is now a local decision to be made, at least as we say here today, right? What mitigation efforts, how that's going to look, at least in terms of an enforcement mechanism, that there isn't state enforcement of any sort of rules or mandates at this point. They are recommendations to local school districts in terms of what local school districts are going to recommend or require. But I think that one thing that we've been pretty consistent in discussing in all of our various time together and many of our conversations with clients have been the liability risks that are incumbent with doing anything that's different than following the IDPH and ISB recommendations. And I think that we recognize as part of that it relates, of course, to whether or not we are making reasonable decisions related to health and safety, so we're not breaching the Tort Immunity Shield. I think it makes sense because we recognize that unlike other places of public accommodation, school districts stand in loco parentis and therefore have more control and discipline over the students who are present, and therefore have to take a different approach to these things than maybe Walmart or Schnucks or County Market would in terms of their enforcement. And I think most importantly is when we adopt something that looks like it's plainly different from the recommendations from health authorities, that definitely increases that liability risk. And so when we use words like optional, that you won't find anywhere in the CDC guidance, when we insert political statements into our back to school plans, that even if they aren't partisan political, but when it looks like we're making decisions based on things like using terms like personal freedom, I'm concerned that that would be harmful to a school district facing litigation on a tort case related to COVID-19. So I think that the liability risk now has definitely become front and center as part of the decision-making process for local school districts.
Yeah, I think that it's worth noting that local control also means local liability. So what I don't think that ISB and CDC have done is to eliminate any basis for liability. In fact, I think all they've done is to shift that basis to you. Last year about this time when Brandon and I were doing our maybe second or third Ask Me Anything, we noted that so long as CDC and IDPH were giving guidance, that meant they were liable for it. If they made the decision, it was their liability, and that was important for defending schools. Well, this year what they've done to you is to make you liable. And I think that so long as they're making you liable, you should be alert to the fact that that means that if a parent is upset, they're coming to you to sue you. And I think what's really important about that is that I heard a lot of school districts say, well, we've ameliorated the concern for those parents who are coming to our board meetings. And I got a call just at the end of last week from a board president who was very concerned because they had engaged a mask optional policy and they had a very different group of very angry parents. And he said, I don't understand, we did what they wanted. And in our discussion, he said to me, one of the things that occurs to me is we did what this group wanted, but it occurs to me there's another group that maybe we weren't hearing from so much. Where did they come from? And I think it was really telling to me that he was saying, it's a practical reality right now that the people who are getting their way are quiet and the people who aren't are loud. And as soon as we give them their way, it's going to go the other direction. And so one thing that I've cautioned a lot of people is a lot of administrators have called me with a lot of burden on their shoulders saying to me, I feel like there is no right decision. And I really feel that. I think that's the right way to view this. There isn't a right decision for the community. I think we need to focus ourselves on what's right to keep people safe. Because if you focus on that, not on the politics, not on what's right for the community, not on what people want you to do, but rather what keeps people safe, I'll defend whatever it is you did to keep people safe. There was a great back and forth on Twitter that I saw just recently where somebody responded to an administrator who said, look, I'm doing what I can to keep people safe. I recognize my decisions may not come as fast as you want, but they are going to be the right decisions when we reach those decisions. So please be patient. Somebody said something to the order of, you realize that only 18 kids in Illinois or 16 kids in Illinois have died of this. More kids usually die of the flu. And the first response to that was another, what I presume to be another parent in the district that said, how come you're okay with 16 kids dying? And that statement just hit me like a ton of bricks, because I thought to myself, if it were my kid that died, I can understand that. I can understand that reasoning, and if I were my attorney, that's how I'd want them to make the case. This case strikes me, the case that's going to come strikes me as the Ford Pinto case. For any of you who may not remember, Ford got sued because they had developed this cheap car, the Pinto, that had a gas tank at the back. And what they discovered after putting it on the road was that every time the car got hit from behind, it would explode. Good place to have a steel gas tank is the back of the car. But Ford's engineers and accountants and actuaries determined that to re-engineer that car would take something like $300 million. But based on the likelihood of claims, they figured out it would only cost something like $50 million to pay out families of people who got injured. So they decided to leave the tank where it was rather than engineering the car. And that's one of the first major punitive damage cases that we've got. And it's not exactly a tort immunity shield breach case, but it's very similar analysis. I think if we make the determination, and I heard a board member say this mercifully during an open session that wasn't taped, something to the order of, are we really sure that this is going to be more deadly than the flu? I don't want to hear that ever in our decision making. Even if it's only as deadly as the flu, we need to do what we can to make it less deadly. Whatever it is, less deadly. We should not be taking into account a reasonable number of kids that will die. We should be taking into account we're doing everything we can to prevent any kids from dying, any staff from dying, anyone from getting injured. And if that's our standard and something goes wrong, the worst case scenario is I'm going to argue that's negligence. And I think that's where we need to be focused as we make our rules.
Yeah, and I'm doubly concerned in those districts where the public messaging has been more of a political nature, that's going to be very problematic if we end up in a situation where there is litigation related to that. So yeah. I think that the answer is, there is risk, and the risk is that we're going to have extreme liability without insurance for it, as many districts' insurance policies don't cover contagious diseases, and I think that's a factor we've got to keep in mind.
And Brandon, I also think it's noteworthy that change to the CDC guidance really made tough that mask optional policy, because before our defense was based on the pragmatic enforcement, that we just don't know who's vaccinated, who isn't. We may not be able to track that on a day-by-day basis about who's walking in. Teachers may not know the differences among kids, or they may forget. And of course, that's going to be a moving target over the year as more and more people are vaccinated. That was a really good argument we had in our defense as to why we couldn't enforce that rule. Now the rule is no longer an arbitrary basis. It's no longer a statistical basis. It's require masks for all. That defense goes away. To my mind, this is going to be a switch. Either you did what CDC recommended or you didn't. And I think that to the extent that we're not doing what CDC recommends, I think we're going to have some difficulty in the defense.
You guys have some great questions today. I'm really excited to answer some of these. These are going to be some great points on all sorts of topics.
Yeah, no kidding.
I can't wait to get there. So while we're on this topic of masks, I want to go through the other mask questions that we have. The next one is, do you think that having students who decide not to wear masks sign a waiver is a good idea? And my answer to that is no, I don't think it's a good idea. In fact, I think a waiver might do more harm than good when you get to the student who didn't sign the waiver is the one who's going to sue you, right? Because remember, the purpose of the mask is not to protect the person who's wearing and not wearing the mask, is to keep them from transmitting it to somebody else. So it's the kid who is wearing a mask who, caught COVID from the non-mask wearer, and that kid who is wearing a mask didn't sign that waiver, And they're going to use that waiver against you as a sword, saying you fundamentally misunderstood the purpose of masks. You didn't make a decision based on health and safety. You made a decision based on this person's individual decision whether they wanted to wear a mask or not. And I think it actually would be more hurtful than helpful in litigation if someone were to get sued if they had kids or parents sign a waiver around masks.
Yeah, I agree, and I'd go one step further. That the plaintiff that concerns me is not the guy wearing the mask, is not the guy who chooses not to wear the mask, but rather the guy who does wear the mask. That's the potential plaintiff. Now, you may say to yourself, how are you going to prove transmission at school? And while I acknowledge that's a heavy hill to climb, the waiver itself speaks to the idea of deliberate indifference, speaks to the idea that we didn't necessarily understand the purpose of the mask in the first place, speaks to the idea that we wanted out of the business of enforcement, and thus we were deliberately in derogation of our duties. So remember that you have the right to waive somebody. If you're jumping out of a plane, that's an inherently dangerous task. You can waive negligence in that. Oops, I forgot to connect this cable and the chute didn't open. But you don't have the right to waive. You can't waive me pushing you out of the plane without a chute. And that's what we're talking about here. That waiver is me pushing you out of the plane. If it's an inherently dangerous, and by the way, remember, you can't be liable for negligence anyway. So you can't waive the very thing you're trying to get them to waive, which is willful and wanton misconduct. So I'd steer clear of the waivers, and I'd just do what's best to keep people safe.
So a couple other questions here on masks while we're on this topic. We're going to move on to our next topic. What about medical mask exemptions? Both the guidance from last year, the guidance from this year, including today's updated guidance, says that we do have to consider accommodations for those who medically are unable to tolerate a mask. I think given the change in enforcement, it makes it probably a little bit easier in some of those situations for us to be able to grant that exemption as an accommodation.
Agreed.
But for a student, remember, any medical mask exemptions is going to have to be based on disability. So it's going to have to be through a 504 plan or IEP, depending on the student. And for an employee, it would have to be through an ADA interactive communication process if we're going to consider medical mask exemption for staff or students.
Yep, and I think we're going to have to be very careful to consider each of the individual circumstances. What I worry about is the floodgates open because one person says blank and then everybody else ... I'd be cautious before you make those determinations that you seek sufficient information, and that if you are eliminating mask requirement on any individual as an accommodation, that you're very carefully considering bargaining implications, and you're also very carefully considering other layered mitigations to do the best we can to avoid that transmission likelihood. A lot of school districts last year had success with spacing a lot of people out, putting on shields as a redundant measure, having mask breaks, having people in separated rooms. There's no reason we can't continue to use what we learned in those previous years as we develop our accommodations for this year.
Question here, back to masks. What about central offices with no students present? Should they wear masks? Well, right now, the CDC's guidance is in any indoor facility, regardless of vaccination status, masks should be worn. I will tell you, as you see me right now, I'm not wearing a mask while I'm in my office by myself. Actually, the only person on the entire floor that I'm on right now. But then in our office, we're having that conversation, given the CDC guidance about going back to anytime we are leaving our office, regardless of vaccination status, wearing a mask here, because that's currently the CDC recommendation. I think that you've got to make that decision. I think that right now the CDC recommendation would be anytime you're indoors where distancing isn't possible, you're going to have to wear a mask in situations, regardless of vaccination status.
Yeah, one thing that I think is important that maybe isn't getting as much attention as it should, I want to point out that the CDC's guidance changed because of a study the CDC commissioned, which had to do with the viral load of COVID infection in people who were vaccinated versus unvaccinated, and they found it was the same. In other words, even if you're vaccinated, you still have, and you come into contact with COVID, you may have the same amount of COVID in your nose and mouth, that is the transmission sources. You may have the same amount of COVID, and therefore you're likely to transmit that COVID to someone else. I think that's very important, because the reason for the change isn't necessarily arbitrary or political, although, I mean, certainly someone may argue it is. The reason for the change is based in a study. And the reason that's relevant to you, and the reason you need to know that, I don't mean that as any statement about the CDC or their reliability, but rather that in the event there's a lawsuit on this stuff, one of the ways they're going to make their argument is the statistics said that blank. The statistics prove that blank. It's not just a matter of the rule said this, it's also the rule said this, and this is why it's the right rule. And so one thing that I caution districts is, because none of us or very few of us anyway, are statisticians, doctors, epidemiologists, etc. One thing that you should be alert to is that when these rules are made because of a change to the data they have, that's going to be a very good argument for plaintiffs in whatever it is they choose.
A few more mask questions before we have several close contact, but a lot of quarantine and close contact questions.
Wow.
But I'm going to take these kind of in order that I think makes sense here for the conversation. If we get back to the point where masks become recommended for those who are not vaccinated only, how do we determine vaccination status of students and staff? The answer is we ask them.
Yeah, prove it to me.
Nothing that keeps us from asking that question. We should probably be asking that question. I mean, honestly, if you're making a decision about masks and you don't know what percentage of your students and staff are fully vaccinated, then I don't think you've done your homework.
I agree.
And I think that's a tort liability concern if you don't know the percentage of your students and staff who are currently fully vaccinated.
And I'd point out as well that if you've got a nurse, you've got access to iCares, which tells you the vaccination status of students in your community anyway. And yes, COVID vaccinations are put into that system. So I've seen a lot of plans that say something to the order of, we won't ask for vaccination status. And I would never make that promise to parents, particularly because you're required to, as a matter of law, on lots of other vaccinations. Just because you aren't required to on this one doesn't mean you won't be in the future, and it could happen during the school year. So certainly my advice would be, don't put that kind of language in there, and be alert to the fact that you may have access to that even before you ask, but there's no reason you can't ask the question. There's no violation of anybody's rights by asking to see proof in the card.
So a couple different questions here, I think, that are all on the same topic. You know, if your plan just uses the language and the guidance that all should wear a mask, and if someone doesn't, you know, it's just recommended and nothing is done, then, you know, we need to really think about, you know, what that, you know, what does that mean, right? And the enforcement piece to it. So is it okay if we just say it's recommended, but then we don't take any enforcement action whatsoever? You know, and that ultimately leads to nobody wearing a mask because it's not being enforced. I mean, this takes me back, I think, to the very heart of the tort immunity issue. And one of the more recent important cases, you know, the Oswego case, where it dealt with what an individual teacher, an individual classroom did or didn't do, didn't enforce the recommended procedures for a student who was having an asthma attack. And I think that we have to be careful about doing nothing. Now, how far we enforce, how do we enforce, what does that look like? I mean, I think that may look very different on a school-to-school basis based on age and other factors in place. But if nothing is done, you know, I think that does still raise the concern about risk.
Yeah, I mean, I want to be sympathetic to school districts and pragmatic reality for those school districts that last year, when a student just wouldn't be compliant, we just removed them remote learning, and you can come back when you're going to be compliant. And this year, I don't think that's going to be an option because of the way ISB's resolution is stated. So I don't know that we're looking at expulsions of kids for refusal to wear masks. I think that may be a heavy hand to play, particularly going before a judge in some counties and trying to explain why we completely removed them from the educational environment because of what amounted to a political decision of their parents, or for that matter, a safety decision of their parents. I think that's a heavy hill to climb. On the other hand, I think that we do need to be reasonable with the kids and do what we can. What I don't want is blind indifference. I made the rule. It looks exactly like CDC. I'm just going to ignore it from here out. On the other hand, I also don't want a policy that's going to be something you can't enforce, because I think that something you can't enforce is where liability comes up.
So I want to go back to a question that goes back to a comment we just made about asking staff and students about their vaccination status. We are hearing HIPAA concerns about asking about vaccination status. Since it's not a mandated vaccine, you don't agree. Well, one, I don't agree because HIPAA doesn't apply. Right? There is no HIPAA rights at issue here with an employer asking employees about vaccination status or a school asking students about that. HIPAA is about healthcare providers protecting your health information. And so there's no HIPAA issue there. Now, obviously, we've got some privacy rights here, so we have to keep that information private. We can't be publicly posting or sharing other employees, vaccination status. But as the employer, as the school district, we have a right to know that information and to ask for it. In fact, with students, you can find that out through, you find out through eye care and your school nurse, and there are ways to get that information without even asking, to be honest. So I think that we recognize that that's out there. So no, while there is some, we have to make sure that once we have that information, we are treating it appropriately, confidentially. There is nothing that prevents us from asking or requiring that information.
Yep.
One last question here on the mask issue before we get some of these close contact questions. For clarity on mask policies, are you recommending districts recommend masks for all, or the districts require masks for all? Or is it at this point, are we still okay recommending masks for all? I mean, I think anything short of requiring has risk. So if you're asking me to sign off on something to say, where's the risk? I think anything short of requiring, following the guidance and enforcing it. I guess that's what I would say. Following the guidance and enforcing it has risk. Anything less than that is a matter of how much risk you can assume. And I guess that goes back to the question, are you, the Ford Motor Company, willing to assume a certain amount of people dying because it's going to be cheaper or less politically problematic for you than not? And I think that's where the risk comes in.
And I think there's a temptation, I saw this in somebody's writings. I think there's a temptation, another firm's writings, there's a temptation to look at ISB guidance, IVPH guidance, CDC guidance, and say, well, they're not mandating it, therefore if I just use the word recommend and I move forward, I'm compliant with what they've written. And what I'd caution you is, just because they're saying that there's no police officer standing by the road with a speed gun doesn't mean that it's not illegal. You all know, I grew up in the country. I grew up literally facing a farm field. And you all know from facing farm fields that there are roads where there hadn't been a police officer for 40 years. And you could drive really fast down that road. It doesn't mean the speed limit isn't 55. Speed limit's still 55. It's just that if you hit, the risk isn't getting a speeding ticket. The risk is you hit a kid and kill him. In the event that you're doing 55 and you hit a kid and kill him, the worst that happens is a negligence case. You can't be criminally liable because you were sub the speed limit. You were doing what you were supposed to be doing. You're paying attention to the road. Kid got out in front of you too fast. Couldn't see him coming because there was a bush there. That's negligence. That's not criminal liability. If you're doing 140 miles an hour, what do you think the jury likely believes? The jury likely believes you were intending to take on that risk, and lo and behold, it happened. That's the case here. What ISB said is not, we're not requiring masks. They're saying we recommend that you require masks, But we're no longer going to stand there with a speed gun and check to see if you're following the speed limit. If you choose not to follow the speed limit, that's going to be on you, and it's going to be your liability, not ours.
I think that's a very appropriate analogy.
Yeah.
A related question, back to the vaccination question regarding, close contacts and quarantine rules are different between vaccinated and unvaccinated. They have a list of the vaccinated students from the school nurse, from eye care, great. It's going to be updated. The concern here is about who we share that list with, principals, secretaries, or others. Since I came from a school nurse who is subject to HIPAA, and I would stop there. I'm not sure that your school nurse is necessarily subject to HIPAA. This is probably more of a FERPA and student records issue, because there's a very specific guidance out there. School records are not HIPAA records, even if they're from a school nurse, unless we are actually medically transmitting billing records. So the HIPAA concern is a little overblown. Privacy, yes. HIPAA, no. So I think where we would go back to in that regard is your FERPA circle of trust, right? Who has a current demonstrative, educational, administrative interest in that information and the furtherance of that information, which means it's probably acceptable to share that list with the appropriate principal or secretary who is tasked with determining information related to close contacts or information in that regard. And the related question here, should every student carry their vaccination card? I don't think that's necessary if the school otherwise has that information. I mean, I carry mine everywhere I go just because I'm proud of it. I don't know. Makes you feel better about it. I don't know, but I think that's, I don't know that students need to carry it if we have that ability to have that information otherwise shared.
Yeah, CDC recommends that you keep them on your person. Obviously, I don't think there's any harm in the child having it on their person, but I don't know that we as a school district need to require that for them, because again, so long as that information is stored locally in some place where it can be checked before any changes are made. Obviously, I think that the questioner speaks to a reasonable concern, which is that if we were to move to some more limited policy on any of the mitigations, be it masks, be it quarantine, be it anything else, we always have the risk that we direct someone on the basis of an expectation of unvaccinated status, where in fact they're vaccinated. And I think that's why it's important that we have checks and balances, and whoever's making the final decision has the information necessary at their fingertips.
If a student has been reported to the health department as a close contact, and the student returns to school anyway the following day, what's our recommendation we'll give when they show up? I mean, the issue there is they need to not be there. So if you had a student who was not permitted, what would you do? I mean, you would isolate them, first of all, and call their parents to come pick them up. And when the parent refuses, then we would look at probably involving the health department and or law enforcement in transporting them home.
And a lot of schools dealt with this last year, and there was DPH guidance on this very issue last year, which was that if somebody came and was suspected or known to be symptomatic of COVID, that we needed to separate them in a room. We needed to have a staff member in the room. That staff member needed to be masked. The person who was being isolated needed to be masked, and they needed to be more than 6 feet apart. In fact, IDPH recommended double distancing if possible within that room, and that person then would remain in that period until somebody could safely transport them home. And again, just as Brandon said, I think that it's important that we treat any trespasser, because legally that's what they are. When they're quarantined and they violate quarantine, they become a trespasser on your school grounds. We treat them the way we would a kid, but also the way we would somebody who's not legal to be there.
Related here, and I think your question brings us to this one, a board member who is an attorney, that's always fun, stated, I mean, I love attorneys, right? Love most attorneys. Stated that if the health department will have to take a person quarantined as a close contact to court after 48 hours, then the health department can mandate the quarantine. My health department administrator looking into this In other words, close contact quarantines are voluntary. Thoughts? Well, they're not voluntary. It's just a matter of how to enforce it. So there's a difference here between how the health department can enforce it and how the school can enforce it. And the school needs to be a partner in that regard, which if somebody shows up, we're sending them home. Now, the process through which the health department can enforce somebody who breaks quarantine, right, there are some steps there in the law for the health department to jump through in order to get a court order to enforce that quarantine. But short of that, I think the school district needs to be, coordinated.
Yeah, and remember that our duty isn't to assure that someone is quarantining in their house with barricade. That's way beyond what we as a school
That's
district
health department's
do.
job, not our job.
Exactly. Our job is only to communicate the information we know to the health department. And just as Brandon said, our job is to be good partners. I'm aware there are districts out there that have taken varying positions on how much cooperation they want to have with their health department. But again, just from a tort immunity shield standpoint, and frankly, being good neighbors standpoint, our job is only to communicate what we know. The end of our authority is, I know that Jimmy was sitting next to Bobby this hour. That's all I know. I provide that information. Once they issue the order, our job is not really enforcement of that order. The state's attorney and the individual and the health department, that's among all of them. I don't want any part of that business. I do not want into a criminal matter on somebody else's behalf. I just want to enforce the rules. Okay, Jimmy is now subject to quarantine order because the health department told me so. My only job is to notify the health department that Jimmy showed up to school. That's it. And then follow the rules they give me for what I'm supposed to do at that point. I've got to segregate that student because that's what they require me to do. Enforcement, if somebody's saying they would have to go through more steps before that becomes a criminal matter, I agree, but that's not, I'm not invested in the criminal process. That's not my problem. My problem is only making sure I do what the health department tells me to do and communicate the information I have.
Related to that, are we required to provide information to our local health departments? Asking in preparation for a board meeting parent questions. I mean, I think that what we've seen from the federal and state guidance over the past year is that under FERPA and the Student Records Act, to the extent it's necessary for health and safety, and these situations fall within that category, we certainly are permitted to. Obviously, there are ways that they can require us to do that through FOIA or other orders, but I think that we do have an obligation there to, again, cooperate. David?
Yeah, so actually, I just looked this up. So the Illinois Emergency Management Agency Act and, the Illinois Health Management Agency Emergency Act specifically requires cooperation in the event of an emergency declaration, which we are still under. The governor just extended it through August. And failure to comply with a request for information and cooperate with your Department of Public Health does potentially put someone at risk of a violation of the criminal code. It's actually 31-9 of the criminal code, and it's titled Obstructing an Emergency Management Worker. Now, I acknowledge to you, I'm not sure that a state's attorney is going to want to file criminal charges against an individual for failing to cooperate with a health official in the event of a quarantine order or something like that. Or a failure to communicate with that person. I acknowledge that it's not likely to be a criminal process, but you should be aware it's out there. And so if you're taking, I think those facts change if you take I'm going to thumb my nose at this authority viewpoint and you advertise that. I think you're begging for somebody to come after you to make an example. And we've seen all the way along the way here that every time somebody gets out of the shot put first, they become the first target. And so if you can hang back a little bit and sort of see what your neighbors are doing and have a cooperative view with other agencies and other groups, I think you put yourself in a much better position to not be the target case. And of course, none of us Look, as much as we may like attorneys, Brandon, none of us wants to spend a bunch of time in a room with attorneys. That's where we're sitting in our own offices, right?
I think that answers that. So a couple remote learning questions. Some of these good questions: pride flags, critical race theory, teacher evaluation, special ed. I can't wait to get to these other questions. But let's get through these remote learning questions, because we've got a few, and then we'll get to some of these other new bills and other things that folks are asking about. Let's start with sort of the big picture question here that one person asked: do we have to offer full remote option for our students? At the end of last year, we required a doctor's note for the full remote option. Do we still need to follow that plan, or can we not offer it at all? I think right now the issue is there is, we're kind of back to full in person, and that really I think our only requirement to provide something other than in-person instruction are those students who do have a medical basis for that, which falls back to homebound. Right? I think that connects back to the homebound statute. A student who can medically certify that they're unable to attend in person is a student who, regardless of remote learning or the pandemic, is a student who qualifies for homebound instruction. Right. And these regulations have long permitted that to be provided through virtual means. So I think that when we're talking about remote learning this year, we're really talking about those students who qualify for homebound because of non-COVID reasons, because of a medical condition that prevents them from being in person because of the pandemic, or because they're going to enter quarantine for a period of time that would also qualify them for homebound. I think that's where we have to be thinking about remote learning this year, is really, in my mind at this stage, through that homebound lens.
Yeah, I remember that the ISB resolution now prohibits remote learning for all, so to speak, and requires it only for those students who are unable to be vaccinated and subject to quarantine order. But just as Brandon said, to the extent that you've got a child who is unable to be present in the school district, you're going to follow your homebound rules.
All right, well, I'm going to start going through these questions in order.
Okay.
On a variety of topics. So I'm going to go back to the first question on the list that's not pandemic related. Now we can come back to some of these questions, right? So if you have got other questions about masks or remote learning, please ask them. But let's jump into some of these other topics that are going to be all over the place. First one's a special ed topic.
Okay.
I presume, David, you're going to let me answer this one.
I am.
Our district is moving towards offering more co-teaching at the elementary level. It's a big shift. We're working to build capacity and staff to make it a success. That's awesome. As we implement this, would an IEP amendment be adequate to change the service minutes? Or do we have to have an IEP meeting? What if parents are on board with this change? Could we do an amendment for this? Well, let's take a step back. An IEP amendment is to make a change in the IEP that's agreed upon by the parent in the school district without the need for a meeting, assuming an annual review has already happened. So generally speaking, the regulations would permit you to make a change to the IEP where both parties agree no meeting is necessary and agree to the change. However, the caution from ISB, from the Department of Ed, and from the case law is to be careful about using the IEP amendment process to make big changes like a change in placement. And certainly while I think the move to co-teaching is great, that is a great inclusive practice that I'm all for, I think that, here's the lawyer's short answer, it depends. How much time are we talking about changing for the student, right? If this is going to change, fundamentally their EE code, for example, on their IEP, then I'm probably going to want to have a meeting to document that change. Even though it is to a less restrictive setting. If it's not going to affect their EE code, it's just going to be more of that minor change in minutes of special ed time, then I think an amendment is possible, assuming it's properly executed. Okay. Critical race theory has not been brought to the floor of the General Assembly as far as I know. Is this still true? Also, when CSE was sent to the governor, Senate Bill 818, that's the Comprehensive Sex Education Bill, was that signed yet? Senate Bill 818, which is the sex ed bill, has not been signed yet as of this morning.
I was going to say, as of 8:30, it wasn't.
So unless that's changed really in the last hour or so, then no, it hasn't been signed yet. And no, there is no statute at this point for school districts or regulation related to critical race theory that became law or regulations in any form at this point. So I know we've got a couple questions here on these broader, more, I call them controversial topics because they create controversy,
right.
Not because I necessarily, I'm taking a view on them one way or the other than it's clear to me that some of these topics like the sex ed bill and other things have certainly created controversy. And so I think that's worth talking things through. So at this stage, there is no state mandate related to CRT. The sex ed bill, I presume, will be signed, but has not been signed yet. Senate Bill 818.
It's passed both houses.
Now, a couple other questions on that particular topic. Here's the related question that in the past, parents had the right to opt out of the sex ed curriculum and immunizations. I have a parent pushing an opting out set of forms that they're saying is their legal right to opt out of: human sex education, sexually transmitted disease, immunizations, mental health screening, education, and critical race theory. Can parents opt out of all of these? I've seen the form you're talking about, and the form is not a good form because the answer is in many of those cases, there are the ability under the school code existing, or once Senate Bill 818 is signed, there will be a process for parents to opt out of that. But the form specifically as it relates to things like mental health screening, immunizations, critical race theory, among other factors, that form is not a form that I think is legally appropriate for those purposes, in part because opting out of immunizations has very specific procedures that are required in the school code that still require a medical certification from a healthcare provider, even for a religious exemption at this point. So there are very strict rules about how to go about that. So generally speaking, do parents have the right to opt out of a sex ed curriculum? The answer is yes. And that would continue to be yes under Senate Bill 818 on an individual basis. Opting out of immunizations is not legal just to say I opt out. There is a religious or medical exemption to immunization requirements, and there's a very specific process through which a parent can have their medical or religious exemption certified in order for them to still be able to attend school.
And I think here it's important that we go back to the basics of education, because I think that a lot of the community this year is going to be imbued with a view that they have more authority than they actually have with regard to school curriculum. Let's not forget that how school curriculum is set. Generally speaking, there's a state law that mandates a particular curriculum. ISB then sets rules for the adoption and implementation of that program. The school district creates a policy requiring the implementation of that program, and then the teachers teach it. As a general matter on all school curricular issues, parents do not have the right to opt out of whatever curriculum they don't want their kids to learn. So they don't have the right to opt out of history class. They don't have the right to opt out of business ed or opt out of PE or ... School's decision to allow a parent to opt out comes down to whether a school district is legally required to permit a particular opt-out. And be aware that there isn't one form you can just sign to I hereby opt out and then list your classes. It doesn't work like that. Each statute has its own opt-out requirements, and each statute has its own opt-out procedures. So if someone shows up and says, I opt out of blank, they have to have met that statutory requirement. As Brandon said, that's different for immunizations than it is for sex ed, both of which do in fact have opt-out procedures, but they are different procedures. You need to meet the one for the one that you're requiring. And because there is no curricular requirement for CRT, there is no opt-out for CRT. It's the creating a solution to a problem which has yet to exist. So there is no opting out of that procedure. If some parents come forward and say, you need to allow us to opt out of CRT, or you should not teach CRT, or whatever, to my mind, and because this is happening at board meetings all over the country, and it's happened in Illinois a whole bunch, to my mind, the basis discussion at this point is we don't set those curricular requirements. Those are set by the state. If you have a concern about the way the curriculum is required for a school district to teach, we're not required to teach CRT, but if you have concerns about whether we will be, you need to take that up with the state, not necessarily with the school. I don't want to, what defines CRT is complicated and debatable, and so I don't necessarily want to get into whether we're teaching some element somebody doesn't want us to teach. But again, parents don't have the right to opt out generally of elements taught in the school curriculum.
Yeah, and I think this is something that I just want to follow up on more, because this comes up in a variety of contexts. Obviously, the two that are coming up most frequently right now are sex ed and critical race theory, but the courts have been pretty plain in saying there's no First Amendment right for parents to just opt out of parts of the curriculum that they might find offensive, even if they claim religious grounds for that. The federal courts are pretty clear in saying exposure to contrary ideas doesn't violate one's own exercise of religion. And so, being exposed to LGBTQ history, or being exposed to Harry Potter, or being exposed to, different aspects of the curriculum, even if it may not be quote unquote what someone believes from their religious perspective, it doesn't mean that exposure to it necessarily is violative of their free exercise. And so, obviously when we're talking about overtly religious content, that has a different legal analysis, right? We're talking about the lemon test. But when we're talking about something that has predominantly secular purpose, like LGBTQ history, like teaching, sex ed, like teaching,
race
other
history
aspects of the curriculum,
sure.
That is not an overtly religious act, and therefore we're talking about the right to opt out is very limited. And my concern, frankly, is if we're too quick to allow the opt-out, that creates other issues, right? If we allow parents to opt out of our LGBTQ history curriculum, for example, what message are we sending to our LGBT students and how welcome they feel at school? If we're allowing parents to opt out of appropriate conversations about race at school, and we later have a race harassment case, I think that's problematic for us. If we're freely letting parents opt out of consent education, and we've got a bunch of sexual harassment or sexual assault cases, I'm concerned about that. And so, or we as a district are opting out and not providing that consent education, I guess I should say. I'm concerned about what that means for us down the road in some of those other situations. So I want us to be very, very careful about those opt-out decisions and not just making them automatic.
And I think that it's important too at this point to get the perspective from in litigation, because we recognize most of you guys aren't in litigation all the time, and of course that's what Braun and I and the rest of us at Miller Tracy are doing with most of our days, is constructing defenses when something's gone wrong. And when we're in the midst of that litigation situation where somebody has sued, it doesn't usually come in, you were teaching critical race theory. Not that suit couldn't happen, but that's not usually, we don't usually get broad-based curricular lawsuits unless we're teaching specific religion within a classroom. Usually the cases come in that somebody was bullied on the basis of blank, or somebody was harassed, or some decision wasn't made that supported this child's education through the IEP process. And then what happens as we work through discovery is one of the questions that gets asked routinely of us is, that we have to answer is, what did you do to try to prevent this stuff? And that's where Brandon and I and Ellen and Christine and Anastasia are working through what are all the things the school district did to prevent kids from treating each other this way, or what did the school teach that might have reduced the likelihood this was going to happen. And that's where we get into that deliberate indifference standard again. It's a little bit different with a race-based case or with an LGBTQ gender rights case or a gender identity case or any of those, but it's a very similar standard where we're looking at what did you do affirmatively to try to prevent this from happening, to prove, because again, I can't prove the universal negative. I can't prove that nobody ever said anything that could be bigoted or sexist or genderist or whatever. I can only prove that we did take these actions to prevent it. So that's where those affirmative steps you've taken over time will be very helpful in terms of our defense. And so when we look at your curriculum where you've got a bunch of parents who've opted out of the tougher parts of the curriculum, that's their first proof, is this was one of those kids who opted out. And that opting out is exactly how we got here in the first place. You didn't take those affirmative steps.
Yeah. Your point raised a question that I've gotten frequently, but isn't yet been asked, so I'm going to point it out and then make a shameless plug, which is the question is, do we need to update our Title IX training for this year? Just a quick note here on Title IX, the 2020 rules are going to be in place for a year or two at least. The Biden administration says next May they're going to propose new rules, but we're probably still another couple of years from those taking effect. Anybody who got their Title IX training to be an investigator or decision maker, Title IX coordinator last year, but that's probably still good training. There's not a requirement for that annually, but if you've got any new administrators who need that Title IX training, we're happy to do it. Our online on-demand version is still out there. You can sign up for. So shameless plug for that. But do keep in mind that the employee sexual harassment training for everybody is an annual requirement at this point. So we've got to make sure that everybody's doing the state IDHR sexual harassment training annually. But for your Title IX folks, your coordinators, decision makers, investigators, your previous training last year is still good training, although there have been some updates from the Department of Ed on their interpretation of some of that. But if you've got new administrators or others who want to do that, one, we're happy to come and train your folks, or if you would prefer the on-demand version, you can still sign up for that online.
And Brandon, I'd offer, just for whatever it's worth, I mean, this is what we do for a living, and I went through it, and viewed all those trainings when they first went live for us. And I just reviewed them again last week because it's in the middle of an investigation, had a bunch of questions, and I thought, I'll bet the answers are even in there. Even though we write these things, this stuff's complicated. Going back and reviewing it, because I can read the rule 10645 and have an idea of what the rule says, but it helps to have that reminder of the various steps you got to do. And while doing that, I reviewed one step that changed an outcome on one of my report, not the determinative outcome, but the way I'd written a particular sentence, because I realized there was an additional step I needed to take on. And so it's well worth your time to just go back through, send everybody back through it one more time.
Yeah, and I'm posting a link in the chat if you all want to sign up for our on-demand training. The shameless plug is there; it's in the chat. You can have your folks register individually for that training. Hey, back to this controversial topics question. Another good question here. What are your thoughts on a teacher hanging a pride flag in the classroom? What is appropriate to display? What's the threshold? Should this be handled similar to outwardly visible religious or political items in the classroom? Well, let me take the first stab at this, David, and then I'll see what you think about it. I mean, I do think that it is in a different category than religious displays or political advocacy, because those have different special rules related to them. So first, religious displays, because of the First Amendment, um, you know, establishment clause. We can't be promoting religion. Teachers don't have the right, and in fact, courts have said must not place religious items, religious messages in the classroom. So I think that the pride flag is a different category than religious messages because of the establishment clause. I think it's also in a different category than political messages and political advocacy. And I want to importantly define what I mean by political, because the State Ethics Act specifically prohibits any sort of political advocacy in the classroom or school setting, and defines that as advocating for or against a candidate for office, a political party, or a referendum question, things that people vote for. And so a pride flag is not either of those two categories for me, right? It is not a religious message, and it is not political advocacy as it's defined under the Ethics Act, because it's not specifically advocating for a candidate or a party, right? It is instead maybe broadly a political statement, but it's not the same type of prohibited political activity that would be defined under the statute. So we recognize that it's in a different category of non-political, non-religious speech by a teacher. And then I think the question becomes, to what extent are we policing that otherwise, right? Are we saying teachers can put nothing personal or any type of messaging whatsoever in the classroom? I think a school would have the right to do that, but my guess is that you are not enforcing such a rule, and therefore the pride flag stays.
Yeah, I want to put a frame around what Brandon said. I think to summarize all that, it's not speech that we are required to prohibit, political speech. It's not speech that we are prohibited from prohibiting, religious message, or required, depending on how that religious adornment versus religious message, personal versus establishment. It is instead limited open forum. What is the nature of your open forum? And here's what I might do if I were in that situation, recognizing it may be little p politically difficult for you. Walk down the hall and look in the classrooms. Ask yourself, is there anything identifying about any of those teachers, be it their beliefs, be it their welcome to school signs, be it the various other signs they have down
Cardinals banner.
The Cardinals banner, the who they are, or what they appreciate, or who they want their kids to feel, how they want their kids to feel. Walk down the hall and look at all their flags, look at all their banners, look at all their posters, and ask yourself, could this be one of those? Your options are twofold. Your options are leave it as it is, stay out of it and figure I'm just going to ride this out and see what happens. Or two, close the forum. Now, remember that if you close the forum, you're likely to have a demand to bargain, because the teacher with the Cardinals banner, the teacher with the White Sox banner, teacher with the Cubs banner are going to be upset because I've had the Cubs banner up for 14 years. Why do I have to take it down now? That also raises the inquiry, why did that teacher have a pride flag up, and what were you saying about that pride flag in an effort to quelch that teacher's some degree of freedom of expression? Now, generally speaking, the Seventh Circuit case law has been very favorable to school districts quelching freedom of expression, but that doesn't...
By teachers, by employees.
By employees. Generally speaking, your hired speech. However, remember, you still have in big flashing lights a collective bargaining implication, which means that if you make the change and they want to bargain it, you're going to be stuck at status quo ante, doing what you were doing before until something changes in time. And again, I want to remind you of what Brandon said earlier that I thought was really well said and is really important. School is the exchange of ideas, no matter how uncomfortable those ideas may be. So while some parents may be upset, and I don't want to minimize the effect of some of the more difficult discussions in our classrooms. That's what we are charged with doing, is framing those discussions.
Mm-hmm. All right. Have the changes to the restraint and timeout been signed? As of today, no. The governor has not yet signed House Bill 219, which makes some changes on restraint and timeout. I'll just give you the 30-second rundown of that. The big change is, once signed, every school is going to have a committee and a plan on eliminating use of restraint and timeout over a period of time. And the emergency rules, or now permanent rules, are mostly embedded in the statute, with the exception of some additional meeting requirements. So the two big moving parts for us on restraint and timeout are, we're all going to have a committee and a plan to reduce and eventually eliminate reliance on use of restraint and timeout altogether. And there are now requirements to offer parents meetings after each incidence of timeout and restraint. And one of the most important things I want to emphasize when I'm talking about restraint and timeout is, it is not just a special ed issue. Those rules apply to all kids. So if you have a regular ed student who is in restraint or a timeout situation, all those same rules apply. And recognize that ISB has moved restraint and timeout compliance and enforcement. The statute now calls them the enforcer, right? They're not just there for technical assistance now, they're there to enforce the rules on a civil rights basis. They've moved that from special ed department now into the Department of Student Care. So a very different focus on restraint and timeout. Any idea on if or when the governor will sign the evaluation bill? Not sure we should include this change in our plan before we send it off to staff on the first day of school.
Nope.
So yeah, that is House Bill 18, which would change the teacher evaluation cycle for tenured teachers who got a proficient or excellent from 2 years to 3 years. But keep in mind, if and when signed, it would go in effect for the 22-23 school year. So I don't think you need to worry about getting that in place for the first day of school this year, because that effective date, even when signed, isn't until next year. You'll have this whole school year to update your plan accordingly.
Yeah, and another thing that I think is really important with those evaluations, we go through this every time there's a change to evaluations, is the teachers union always wants to make that a maximum competence, a maximum requirement. And my advice is evaluation's a minimum competency exam. Got to do it once every other year. Got to do it once every 3 years. I don't care what the minimum competency rule is. I don't care whether I got to get a C to get into school. I want to get an A. And getting an A means there's never a period when teachers aren't being evaluated. That doesn't mean that you're walking around evaluating teachers at all moment. But guys, we're talking right now, and my guess is that every single person watching right now and who's going to watch later on YouTube is going to be evaluating us. They're saying, well, I like what he's saying, or I disagree with what he's saying, or he taught me something, or gosh, I wish he'd teach me something. I wish I wasn't wasting my time. You're evaluating all the time. I'm evaluating my kids all the time. There's never a moment where I shut that off. And so as I make changes, if I make changes to language, it should be exactly what the statute says, that we're required to evaluate at least this often. At least this often. And don't ever do anything that will minimize the effect of your evaluation or minimize the ability of your administrators to conduct evaluation. So while this hasn't been signed yet and you still have time, I want to take your blood pressure down. If you made no changes at all, your minimum competency is set at last year's minimum competency, which is tenured teachers every other year. And that's what I'd like to see you do anyway.
A bill that got signed earlier this spring, Public Act 101-656. What does that change, or do we have to do anything different with criminal background checks now? And this is a big deal, and so I want to make sure everybody is paying attention to this. Yes, we're still required to do criminal background checks by statute, but there's now a new process that we have to go through in order to exclude someone on that basis. And I would point out, I think there's some excellent examples in the press update in the administrative procedures and exhibits for sample notices and that process. But here's the short version of that. When we exclude someone based on their criminal conviction now, there's an interactive process we have to go through. In fact, for other employers now, it makes it a civil rights violation to make a decision based on criminal conviction. School districts, because we are otherwise mandated by law to do criminal background checks, still have the right to do that. But I think now the effect of the statute that it is, one, we really are limited to those convictions that are enumerated in the school code, unless we can otherwise show that there is an impact on their ability to be a teacher. And two, there's now this interactive notice process that's there. I recognize that there has been some debate over whether this does apply to school districts. I think it was very plain in IDHR's FAQ that it does. And because they're going to be the agency enforcing this, I think that's who we have to go to for that guidance. So please, please, please pay close attention when you're doing those criminal background checks. And if you're going to exclude someone based on a conviction, there is a brand new process that has to be followed where you're giving them notice, a chance to respond. There are timelines related to that. And the easiest way is policy 530 in press. So for all you districts who have press subscribers, and there are sample notices there that I think are well done. So, that's a place to look at for that 101-656 compliant.
Yeah, I had a very good question early in the summer with somebody who had to reject someone, and we were sort of talking through the process a little bit, and I pointed out that the statute's factors have been viewed by EEOC since 2016 as being mandatory. So this is not necessarily new stuff, but we didn't usually take this into account except when somebody was coming to us and we already had the information. That's when we were talking about those factors before. Now, once they fail the FBI background check, we're going to have those discussions again. Guys, you're still not permitted to hire somebody. I acknowledge that you're still required to do it. However, I've had a number of situations in my career where the FBI background check came back and showed a hit on somebody, and that person completed a probationary or a diversion program, and then they got it expunged from their record. I had a teacher who came in with a professional teaching license, and the criminal background check didn't come back for 4 months. And when it did, that person was already in the classroom. We had no choice but to be like, you've got to leave. Well, mercifully, that person had an attorney, and the attorney cleared it up. Look, there's this expungement order. Here's the expungement order. Everything was good. But not everybody has an attorney. And what I worry about is that with this new statute, it becomes much easier for a DHR arbitrator to look at your process and say, you weren't substantively deficient, you were allowed to exclude, or you would have been allowed to exclude, but you didn't go through the process. Now, it's procedural deficiency. The solution is they get the job. Or heaven forbid, we could also have a situation where we just make a mistake. We thought the person was excluded. It turns out there's an expungement order. Or even if we didn't make a mistake, the expungement order never came through like it's supposed to. You need to comply with it for two reasons. One is procedural. By complying, you guarantee you're in your best case scenario. And two, from a defensive standpoint, providing them the information allows them to respond. And the worst case scenario for you is they respond with, here's why that order doesn't matter. And remember, a charge is not a conviction. I see that come up a lot too, that we exclude on the basis of charge, and the person comes back and says, no, wait, I was charged with something. I was never convicted of that. A charge is not a conviction, and therefore they continue to be innocent until proven guilty.
Open Meetings Act question. Has Open Meetings Act been extended to continue to allow virtual attendance and voting by board members? I don't see it in the most recent executive order. Well, I think there's two different things we got to think about. There's the pre-existing Open Meetings Act remote participation rules, and then there's the COVID-related remote meetings rules, right? So the pre-existing remote participation rules have never changed.
Right.
So long as you have a quorum physically present, a member who is absent for qualifying reasons can participate and vote remotely. But that requires a quorum to be physically present. But assuming you've got a quorum physically present and you have a board member or two or potentially three who meet the qualified reasons for remote participation, which means usually personal illness or family or school or work or school district business, right? It can't be on vacation. but they've got to be on one of those qualifying reasons they can participate remotely. Separately, we've got the COVID-related remote meetings. And that's now embedded in the Open Meetings Act itself. And the first prerequisite to that is there has to be a disaster declaration, which we currently have through August 23rd, I think, right now. And when there's that disaster declaration and the head of the public body determines that an in-person meeting is not feasible due to the disaster, right? So the reason that you're not having the in-person meeting is COVID related in the situation, then there's still that process for having those remote meetings as possible, assuming you're meeting all those other pieces. So two different things. The pre-existing remote participation remains in effect, where you still have a quorum physically present. The remote meetings where you don't have a quorum physically present requires disaster declaration, finding by the head of the public body, and those other requirements that are there.
And again, I think that's why it's important, because there are those two different processes to have that finding at the beginning of the meeting that's actually in the record that we're doing this because of COVID, that we are intending to take advantage of that statute.
Special ed question, what new parent notifications do we need to send at the beginning of the year? Interpreters, transition aids, service logs, are those going to be in the ISB procedural safeguards or forms, or are we all creating our own? Well, I have not seen ISB yet update the procedural safeguards to include all of that. It would be nice if all of that got in the procedural safeguards, so that we all had our, I know you all make your copies of those at the beginning of the year, and then ISB changes in September, and we're recycling a lot of paper. But here's my short list of what needs to be there. We need to make sure annually we are sending our policies and procedures on behavioral interventions. We know that we have to provide them notice of their right to request related service logs. We know that we have to give them notice of their right to request interpretation services. And remember, everybody, there are new ISD regulations that went into effect this spring on qualified interpreters who can serve. For a parent who doesn't speak English, as a qualified interpreter at an AP meeting, and our requirement to be there. And that notice that students who don't qualify for special ed may have rights under 504. Those are things that have to be there at the beginning of the year notice in your handbook or otherwise. And then as to each meeting, we have to make sure we're also providing notice of, we have to give the draft 3 days ahead of time, the right to request related service logs, the right to inspect and copy student records, and those interpretation services as well. Those all need to be there. The other piece that's out there for us to keep in mind is the change with those 22-year-olds who are eligible under 102-173. That was House Bill 2748. The governor signed it last week. It's now Public Act 102-173. There are actually two different bills, or now statutes, related to 22-year-olds. One is 102-172, which extends eligibility for all 22-year-olds going forward. So going forward, if someone's 22nd birthday falls during the school year, they remain eligible through the end of that school year. So if I'm an IEP student, previously, and say my birthday is September 15th, previously my eligibility would end on September 14th. Right? Now I have the right to my IEP services through the end of that school year, right? Important caveats there, for example, we can't use IDEA funds for those services beyond their 22nd birthday because of the federal rules that exist. And ISB did just publish last week an FAQ document. I've got it over here if I can reach it, on Public Act 102, 172, and 173 that I think is helpful. And that leads me to the other notice, which is 102-173 is a bill that would allow extended eligibility for those students who turn 22 during the pandemic and during a period of time in which their in-person services were suspended for a period of 3 months or more. So for those students whose in-person services were suspended for 3 months or more, and they turned 22 during that period of time, then they are entitled to services through the end of the 21-22 school year. And we have to provide them notice of that within 30 days of the effective date of the act, which was last Wednesday, right? So that clock is ticking. So if you had any students who had their in-person services suspended by the school district for a period of 3 months or more, and they turn 22 during that period, then they have a right to extended eligibility. There's some caveats and things that need to go in that notice. If that is a topic that you want to hear more about, Barbara from ISB and Terry Engler and I are doing a webinar on that next week. I don't know if it's been fully advertised through IAASE and CELA, but I think on the 11th at 3, tentatively. So I think I'd be announcing that for the first time, but so I don't know if that's been advertised yet by IAASE and CELA, but that's going to be a free webinar next Wednesday to go through those statutes in a little more detail. David, we're down to one more question.
Hard to believe.
Close to time here. We've got to so of course, if you guys have any more questions, please pop them in the Q&A. We've got a retired teacher that's been teaching full-time under the previous act, which expired June 30th. House Bill 2569, which extends that, has not yet been signed by the governor. That's correct. It has not yet been signed. Can we assume it will be? I mean, I think it's going to be. I have every expectation that it will be, but I don't have any special knowledge other than I presume the governor's going to sign most of the school bills that did pass.
Yeah, we're in a unique circumstance right now where both houses and the governor are governor's office are all kind of under the same control, and there's communication. And so that usually means that when bills get an overwhelming majority, they move through pretty safely. However, please be aware that even this governor has in fact vetoed stuff, has in fact sent stuff back. Not a lot of stuff, but it does happen. And the politics shift after the fact. So while we're in the midst of a teacher shortage, I think that we reasonably believe that this bill certainly had traction from the Retired Teachers Association, had traction from the retired administrators, had traction from various other entities, but please be aware it's not law until it's signed. So to the questioner who asked, can I just rely on it and rehire? You can't rely on it, and whether you rehire is going to be a function of how much risk you're willing to take on. I don't think it's huge risk. I'm not suggesting this is likely to get vetoed or that I have any information it will, but at least at this point I'm not aware it's been signed.
Yeah, I think two things about that, which is one, I guess if you at least start the year, you're not going to exceed your number of days.
Right.
So if they at least start the year and the governor ends up vetoing it, you know at that point you're going to have to pull back because you're not going to hit your 100 days yet. But of course, the issue is it depends on the contract you entered into.
Contract, thank you. That's where I was going. Don't enter into a contract for the full year. But at least you both have the same.
On like a sub day-to-day basis until the law is signed at that point.
And you have the same
other
interest.
Thing is to keep in mind that that bill also increased the posting requirements.
Right.
So we got to make sure that in order to do that, we've got to meet those additional requirements of posting, ongoing posting, and who notices have to be published with, including the job board, universities, and on the school district's website in order to do that. So recognize there are some increased posting requirements with that as well.
And I've had some school districts that got the question from their retired teacher, can I just keep doing this? And one thing I'd caution you, remember that you have joint interest on this, that you want the teacher to be able to teach through the year, but they also want to protect their ability to work for the year and thus not lose their retirement. So make sure you're not making promises to that person that are longer than the promises you can confirm in writing. So I always tell someone when they're considering doing this position, please do me a favor and get it in writing from TRS, because TRS rules change often and their management changes often, and that may mean different interpretations of rules. Get your own written opinion from TRS so that we're working together to make sure we're managing both of our interests, because ultimately they are the same.
There's a question, put a plug in for the webinar I'm doing next week with Terry. I think I did plug it. He said, can I put a link in the chat? I don't have a link to it yet. So if you've got a link to it and you want to send it to me, I'm happy to put it in the chat to promote that. But I don't yet have a link to that. So if you send it to me, I will happily do that. Another question here, hearing anything about a lockdown once again for COVID, any rumors? No. Well, I kind of think in the opposite. I mean, again, this is Brandon's crystal ball, so I couldn't be 100% wrong here.
We've never been wrong before during
now that I'm seeing
COVID.
political ads for candidates for governor, including the governor himself, on
Right.
TV during the Olympics. I just don't see mandates popping back up. I think it's going to be recommendations and not lockdowns, but I think if things really go the other way, that's possible. It's also possible that could be done regionally. So I think if vaccination rates continue to lag in central and southern Illinois and numbers continue to go up, I think we absolutely could see ourselves going back a phase in some of those regions and putting some of those mitigations back into place. I would, that is, I think, certainly still possible if numbers don't change. I would predict that that would not happen in swing counties that the governor needs for re-election, but that's just cynical me. Which frankly means downstate, the governor's not relying on those counties and those votes for re-election probably, right? And so could it happen? Maybe.
Yeah, I'll tell you that as I read the ISB guidance, I'm seeing a real reluctance to force anything at all. And while you may feel locally like that provides you a lot of control, my caution is, while I don't see any situation where the governor is likely to start forcing things, or ISB is going to force things more than they have to, I'd caution you that in all likelihood that also means that liability may become a larger concern than it has been to date. And I know very well that there are plaintiffs' attorneys organizing potential plaintiffs. I know that there are lawsuits coming because frankly, lots of people see advertised on the internet that we're lawyers, and they go looking for lawyers, and our secretaries field calls from folks all the time who don't really understand what we do. I can tell you there are folks out there who are looking for the opportunity to take advantage of a large swath of potential you can't go out of business dollars. Walmart seems like an easy target because they can't go out of business, but what about a public entity? Public entity which, even if it dissolves, takes its liabilities with it to the district next door. So I'd caution that we're nowhere near the end of the statute of limitations. We're nowhere near the point at which it's going to be done. And I would not be at all shocked to find that while the governor doesn't want to shut things down, that doesn't mean he won't do things to assist in making it very clear to your local population what the liability is going to be and where it will be held.
All right, David, we've answered the questions that we've been asked. We're getting close on 3 o'clock.
We are.
So I think it's time for our final thoughts, and I'll share mine, which is, first of all, thank you guys. Thanks for hanging out today. Thanks for the good questions, but thanks for what you guys are doing to get your schools ready. You know, many of you who know me well know what an advocate I am for public education, who appreciates the importance of public education. And I think those of us who appreciate and admire public education, we also have to understand and appreciate public health and how those two work together for us. And I know all of our jobs are hard right now because we're dealing with decisions and problems that there's no playbook for. And as we all are getting back to what I think is and should be a normal school year, and what I hope is and will be a normal school year with limited disruptions and limited quarantines and in-person instruction, pandemic isn't over yet. And we have to recognize that. And I think that we will all get there. And we're gonna get there, I hope sooner rather than later, but we all gotta do it together to get there. So I just, again, want to say thank you for the hard work you guys are doing, for the hard decisions that everybody has to make. Because with these local decisions, it's placed, those of you who are listening today, squarely in that decision maker seat, where you're going to have loud people on both sides of these issues, and that is rarely a fun place to be. And so I just encourage you to slow down, make the decisions that are there based on health and safety and good documentation, and not based on overtly political factors. And we really, you know, hope that that leads everybody to a path. They can have a great school year, and the kids can have a great school year. That's what I want.
Tell me about it. My kids are just getting ready to come back from school today. They're finally back in person after an entire year of remote, which, as you all know, trying to manage kids remotely and do your job and get the rest of the things done you got to do. I can't be any more thankful for what you all have done to keep kids safe. And I can say, at least from my experience, it's been shocking how well the kids have learned, notwithstanding how difficult this situation has been. And it's also been shocking how well school districts have managed, notwithstanding a really tough year. I'll echo what Brandon said. I'm not sure there's a great right answer to all these questions. And I recognize that's tough when you're trying to manage switches. I don't know which direction to push this switch. There isn't the right and wrong. I recognize that's difficult. But you've been doing it really well for an entire year. And I encourage you to continue to use that toughness you've gained over the last year to remember that there may not be right answers, but your job when you're a board is to make sure you've got all the information so you know which risk you're best willing to take. And your job, if you're an administrator, is to make sure that your board has in writing the good direction as to what the risks are for the decisions they may make. That's going to be the best protection for all of us when we ultimately get there, so that we can say, so that when Brandon and I are defending you in heaven forbid a lawsuit, if you're the one guy who gets stuck, so that we can say they made that decision with health and safety of kids in mind and with the best learning opportunities for all the kids in the school in mind. And that's how they made their decision. When you do that, those first conversations with us are easy, because while bad things happen, we've got good defenses, and those good defenses make a big difference.
Oh, thanks, David.
Thank you, Brandon.
Good to see you all. We'll see many of you soon, hopefully in person, and we'll talk to y'all later. So thanks for joining us today.
Thanks, everyone.
Record.